Hello everyone, this is Crypto BitLaw back with another blockchain legal brief, and today we're going to be discussing the IRS staking rewards case wherein the plaintiff sued the IRS to get some sort of regulatory clarity on how staking rewards should be taxed, and in particular we're going to cover the most recent development in that case where the IRS moved to dismiss the case. Okay, so we're going to dive on in and kind of parse out all of the relevant pieces of information. But before we do, as always, if you enjoy this content, please hit the like button and subscribe to our channel. Okay, so here we can see CoinDesk reports that U.S. tax agency moves to dismiss lawsuit by Tezos stakers who refused refund and demanded a trial. They say the Internal Revenue Service argues that Joshua and Jessica Jarrett, they're the plaintiffs in this case, they had no right to refuse the refund of almost $4,000, which was paid, therefore the case should be dropped. So let's dive on in and give a little background into this case and see where we currently stand. It states, the IRS filed to dismiss a lawsuit from two Tezos stakers Monday, saying the agency had already refunded just under $4,000 in taxes plus interest to the individuals. Joshua and Jessica Jarrett sued the IRS in 2021 on claims that they should not have had to pay income tax on Tezos tokens they gained by staking on the network. In December, the IRS offered a refund to the couple, who said they refused to accept it so as to force a federal court to make a ruling on whether the IRS can tax crypto gain through staking as income, in addition to taxing crypto transactions as capital gain or loss. In a motion to dismiss and a supporting 12-page memorandum of law filed earlier this week, the IRS said the Jarretts could not refuse the refund and the case should be dismissed. The Jarrett's case has been funded in part by the Proof of Stake Alliance. Quote, despite obtaining the full relief they asked for in their complaint, the Jarretts believe this is still a, quote, live case or controversy because the court has not yet ruled on whether staking rewards are taxable as income when received. They suggest in their letter that they can simply refuse the refund for which they sued in order to vindicate their rights, the filing said. The Jarretts essentially argue that they can continue this case to force the United States to explain why it granted the refund and then obtain an advisory opinion from the court about those reasons. Not so. The tax refund, $3,793 plus interest of $208, was delivered on February 14th, the IRS said. According to the filing, the IRS expects the plaintiffs to dispute the IRS's motion to dismiss, but said none of the possible exceptions would apply, pointing to how tax and tax refund cases are viewed within the U.S. judicial system. Quote, even if the Jarretts make future refund claims based on the argument that staking rewards are not taxable income when received, that controversy would be at most a similar one. That is not enough, and given that this is the Jarretts' first suit to seek a refund after paying tax on the receipt of Tezos reward tokens, the Jarretts cannot show repeated cases evading review, the memo said. The IRS said that there's nothing left to adjudicate and that the refund was not an offer to compromise and therefore the case is over. Plaintiffs may, as they hypothesize, seek a refund in a future tax year, or they may not. That depends not only on whether they are earning staking rewards for any given year, but also on whether accounting for all the other income, deductions, and payments they report on a future return, they report another overpayment, the IRS said. Okay, so that's a pretty big development. The thing that really stands out to me here, it brings up into my mind visions of this legal doctrine called mootness, right? And so in order for a case to be heard, it has to be ripe, and it can't be moot. And by ripe, there actually has to exist an issue. You can't bring a case before an actual legal issue exists. You know, for example, I can't sue you for battery until you actually hit me and create a battery upon me. For me to bring that case before you hit me and try to sue you for battery, it wouldn't be ripe. Same thing exists with mootness. If an issue is already resolved, then that case is deemed moot. And so a court can no longer hear that case. And it seems what the IRS is trying to argue here is that the issue that the Jarretts, the plaintiffs, are bringing is moot. It's no longer a live issue, and they are citing pretty much all the basic principles from this legal doctrine, as we can see here. With regards to mootness and judicial review, it has long been settled that a federal court has no authority to give opinions upon moot questions. That is, when the issues presented are no longer live or the parties lack a legally cognizable interest in the outcome, an actual controversy must exist not only at the time the complaint is filed, but through all stages of the litigation. Okay, so this brings up a lot of issues that you see in federal court with regard to this doctrine of mootness. Courts can only hear cases and controversies. They can't give advisory opinions. They're not there for giving advice. their purpose, their role is to sort out these controversies and then decide and give opinions based upon live controversies that exist. So you can see here, it brings up this other issue that courts, they only hear cases and controversies and they don't give advisory opinions. And then further, this expounds upon the issue of mootness, that if an issue is no longer live, if there no longer exists a case or a controversy, then it's pretty much moot. The parties lack a legally cognizable interest in the outcome. So it seems here that this is the argument that the IRS is trying to make, and I'd like to see what the Jarretts come back and say in regards to their defense against this issue, how they're going to approach this. And so I think that this was all, I feel like it was only natural. It would really, I think what the IRS is trying to do here is to avoid judge-made law from the bench, from preventing a judge from legislating from the bench and then creating some sort of regulatory framework from this opinion, this precedent, this jurisprudence that the judge would give that would then be binding upon the IRS. So I think the IRS is trying to take this out of the court's hands, put the ball back into their hands, the IRS's hands, and then come up with their own regulatory framework with how to approach this, lest they get preceded by legislators who actually enact and pass a law that handles how to tax staking rewards. They could be preempted by that, but at this point, it seems like what the IRS is trying to do is to reserve the issue of deciding that for themselves, because we all know how long it takes to create any sort of law in the United States. It's a long, drawn-out process. But interesting developments. We're going to see how this ends up. And as we can see here is a copy of the docket in this case, Jarrett versus the United States. That's the case at bar. And recently, we could see on February 28th, the IRS filed the motion to dismiss, and then they also filed a supporting memorandum, both of which are here. Here's the motion to dismiss the complaint, because it's moot. Of course, they fully refunded the income. And then here's the memorandum of law in support of their motion to dismiss. So if you want to see these are going to be linked down in the description below. But once again, before we head out, I want to thank you guys for watching. And please, if you enjoy this content, hit that like button, subscribe. That really helps us out. So thanks again for watching, and we'll see you all in the next video.